advocate with her. That's where we stand on that. Finally, the children, through their guardian, Mr. Kane, are represented by my friend Miss Sable, who is present on the link. And I think that is everybody that I need to account for.
Thank you.
We have had pre-hearing discussions, Your Honour, in light of the emails sent and received this morning.
Yeah.
And I think Mr. Jeekins will have more to say than perhaps I will in due course. I have, on behalf of my authority, tried to refine as far as possible and narrow issues. I can tell the court that we will no longer advance the pleading about the home being smoky and untidy, which is paragraph 1C of the threshold, which required the attendance of a midwife. Charlotte Hans is her name, so we can abandon that. The court may take the view that on paragraph 1 of the threshold, the key evidence is that of Dr. Hilton, who in turn relies on the reports and narratives of all the hospital staff and community staff of others, and builds those reports into her considerations and judgments about the adequacy of the parents' care of the twins.
All right, so the agreed witnesses for the final hearing, as far as the local authority is concerned, is Dr. Hilton, Courtney Nicholson as the current author of the final care plans, the mother, the father and the guardian. Is that right?
I'm in the court's hands. I don't seek to resile from any of the pleadings you make. I note and I suspect that Mr. Jenkins will confirm in a few moments that they are attacked. The evidence that I have filed on behalf of the authority is attacked on the basis that it is dishonest, extracted through bullying, that it is invalid because of the attitudes, bias and lying of those who made the statements from all agencies, not just the local authority. And that seems to be portrayed in the letter read out to the court on the hearing before last at CC 153. I don't know if the court has read that.
I have read that.
That, on my understanding, betokens how father puts his case, and to a lesser extent, that's how mother puts her case too. I have put a skeleton before the court. I'm not going to rehearse it, but this is a broad canvas case. We have evidence from all quarters, which sings to the same tune, effectively. And I invite the court to tell us what evidence it needs to make a determination of the threshold issues, for the reasons that I have said in my skeleton, but also because, as the Guardian says in her position statement, these children need to know that the narrative of the parents, if my case is accepted by the court, is not acceptable. It's not accurate. It's not right.
I understand
that. Has to be how they understand their family life and can be helped to keep themselves safe going forward, which is really the only thing that matters to Warwickshire.
I understand, but that position does not necessitate 13 witnesses, does it? But you don't contend that. You say that the court has to undertake a proportionate investigation of the children's lived experience in order to reach what is, as I understand it, apart from Mr. Dawes's continued absence from the home, an agreed plan, which is the children will remain in the care of their mother.
Yes, that's right. The absence from the home is something that the authority is still reflecting on, but I haven't made any application as yet.
All right. Yes. Well, of course, Mrs. Stiles, it's important that I remind the parties that this is my litigation, not theirs. And it is for me to determine what I consider is necessary evidence in order for me to make such findings as I need to determine the welfare outcome of the children. So what I propose to do, having read the parents' evidence and their responses to threshold, is to ask Mr. Jeekins to take me through witness by witness of the list that I have in order to understand what the factual challenge is to that witness, and then I will make case management decisions as to whether the attendance of that witness is necessary and proportionate. So, Mr. Jenkins, just to confirm that my list is the same as yours, the disputed witnesses, or the witnesses that I want to investigate, are Natalie Bowley, Sue Sweeney, Sarah Blewett, Naomi Gound Ateki, is it? Gabrielle Rowley-Clark, Stephanie Maloney, George Hollingworth, Charlotte Hands, Kay Packer and Ellis Brown. So Natalie Bowley first, please.
Your Honour, may I start by saying I'm not in a position, regrettably, to assist the court in this way. As Your Honour is aware, I was instructed yesterday, received my instructions yesterday, I think around lunchtime. I've done my best to work through the 2,844 page bundle. I've never met Mr. Dawes at all, and not been involved in this case prior to today. There is not, and I wish to make clear, I'm not divulging any privileged information. There was not an attendance note in respect to the last hearing. I've done my best to take instructions from Mr. Dawes this morning. By way of comment, Mr. Dawes has been, I think, doing his absolute best to assist me and in turn to assist the court. He has listened carefully to what I've been saying to him and what I've been asking him, and he has been giving quite detailed answers. Your Honour, I accept and concede that the response to threshold, as seen at CC 157 to CC 163, is not helpful.
It's possibly the worst document that I have encountered in my whole of the time sitting as a judge in the family jurisdiction, Mr. Jenkins.
Your Honour,
does your solicitors and Mr. Dawes no assistance at all?
I don't seek to persuade Your Honour otherwise. What I would observe is this, Your Honour. This morning, in the limited time I've had available, I've been working through the threshold document with Mr. Dawes on each and every point. And it's fair to say that he does amplify significantly on each and every point. So it's not a blanket denial. For example, Your Honour, and I won't take you on to each and every one, but if I may take you on to point 1A, if I can paraphrase this to say that the hospital environment and so on. And again, this is my note, not Mr. Dawes' evidence, but he says that the recital in the threshold is untrue. He says that Mum and him were feeding the babies around the clock, and it was only later, when they saw Max's surgeons, that they were advised to change the feeding regime. So significantly, Your Honour, a significant amount of information and challenge to the local authorities' case. Sadly, Your Honour, we have the one word, denied.
Yeah, and Mr. Jenkins, these proceedings have been ongoing since October of 2022, and I'm afraid to say that you can continue if you wish to, but I am unswayed by any suggestion that Mr. Dawes has not had ample opportunity to set his case out. If anything, my view of that document is that it is an attempt to control these proceedings and to stand as a barrier to this court's welfare determination in relation to his children in a wholly unhelpful way. So if your request is going to be that Mr. Dawes needs more time above and beyond the 10 months that he has already had to set his factual case out in writing, I am going to be unpersuaded. Can I make that clear?
Your Honour, I was going to make that exactly that submission. In my respectful submission, Your Honour, Father will not be able to have a fair hearing in respect of the threshold issues if Your Honour does not allow him to respond properly to each and every point on the threshold.
Remind me the date of that document, which gives me the word denied over and over again. In fact, I don't need you to remind me. It was 3 weeks ago. The 17th of July. I think that Mr. Recorder Sangira afforded Mr. Dawes a further opportunity to respond to the document, and that's what he's produced.
We were given till November to pass the information on.
I don't want you to interrupt, please, Mr. Dawes. I'm not interested in hearing from you. You've got the benefit of counsel today.
Mr. Dawes tells me that he would like to file and serve a statement within 7 days, Your Honour, answering in detail each and every point. And in my respectful submission, that is not an unwarranted delay. I cannot explain why the threshold document is drafted as it is, because it's apparent to me that Mr. Dawes is able to provide more detail than the single word denied which we see peppered throughout this document. And in my respectful submission, Your Honour, it's absolutely essential that Mr. Dawes is given a proper opportunity to respond. As I say, I don't know what's gone on between Mr. Dawes and my instructing solicitors. I understand, I think, that my instructing solicitor is on holiday at the moment. And as I say, I didn't have an attendance note from the last hearing. Your 7 days is not, in the overall scheme of things, too much, in my respectful submission to ask, and it will assist in the disposal of this case properly and fairly. Without that, Your Honour, in my submission, Mr. Dawes would not be able to have a fair hearing.
Well, I'm going to refuse that application, Mr. Jenkins, for the reasons that I've already given, which is that your client has had 10 months to engage in these proceedings and to file a proper and meaningful response to threshold that sets out his factual challenge to the allegations of the local authority beyond that which is simply that these professionals were all lying. He has not afforded himself of that opportunity, and I don't consider that there is any merit in me allowing him a further opportunity, because my strong suspicion is that we will simply get a similar document. So I'm afraid I'm going to case manage the case on the basis of the wholly unhelpful and obstructed document that Mr. Dawes instructed to be filed on his behalf 3 weeks ago.
I can do it in
which I would
3 hours.
Mr. Dawes, I'm going to ask Gemma to mute you. I'm not going to hear your interruptions, alright?
See the evidence.
So,
evidence.
There we are. That document, Mr. Jenkins, offers me no opportunity to understand what the factual challenge is to any of the witnesses on the witness template beyond those which I've identified. So why should I simply not proceed on the basis of a final hearing with the necessary witnesses being Dr. Hilton, Courtney Nicholson, the mother, the father and the children's guardian?
Your Honour, Father has provided statements at CC5.
Yes, read those.
And they do set out challenge to in broad terms, to the witnesses that he challenges, that are relied upon, that the local authority no doubt say are important witnesses, that the court on the last occasion endorsed them giving evidence. The father's case is set out in detail there.
Right, well let's go, I mean, if you're asking me, I mean, do you want me to undertake the exercise of cross-referencing your client's statements to the allegations, or are you going to do it? Because in the absence of you being able to tell me what the factual challenge is to Natalie Bowley, Mr. Jenkins, and underestimating the scale of the task, but all of you were aware why this case was listed today. This case was listed today because I became aware of the fact that because of the time frame that you had all provided for the number of witnesses, and because of all of your availability, not yours, Mrs. Jeekins, Miss Forbes, Mr. Forbes, Miss Stars, and I think Miss Fairclough, this case, which has been ongoing since the 19th of October of last year, was not going to be listed until the 20th of November, when the outcome for the children, in large part, is not contentious. Now, it seems to me that that is wholly contrary to the children's welfare best interests. I have identified 3 days in front of me, beginning on the 19th of September, and it's my intention, provided that Dr. Hilton is available, and the social worker and the guardian, to list the case for 3 days then. Now is Mr. Dawes' opportunity, I'm afraid, to persuade me that any other witness is necessary, and I make it clear that I'm not prepared to bring professional people to court when the only challenge is you're biased against me and you're lying. Because Mr. Dawes can tell me his version of events in his own evidence, and then I can weigh up the written evidence as opposed to his oral evidence. So I'm afraid, Mr. Jeekins, I appreciate that you're under pressure, we're all under pressure, but this hearing was clearly listed in order to consider the witness template and the listing. That's what I propose to do.
Your Honour, I'm simply not in a position to take Your Honour through each and every witness that Mr. Dawes had required that was sanctioned by the court on the last occasion. I'd probably need the remainder of today, frankly, to do that with Mr. Dawes. Your Honour may find it helpful to ask Mr. Dawes directly in respect of each witness. I'm
not going to undertake that task, Mr. Jeekins. That's not my function, I'm afraid.
Understood, Your Honour. I simply cannot do that in the time I have. As I say, I think I'd need the rest of today to do that, Your Honour.
Right. Well, I'm going to make a case management decision, Mr. Jeekins, which takes the matter out of your hands. I've spent a considerable amount of time on this case this morning, and I have read all of Mr. Dawes' evidence together with much of the local authority's evidence, and I've considered the schedule of findings. I have at the front of my mind always the need for parents to have a fair hearing. This is a particularly unusual case because, in fact, the welfare outcome for the children is broadly agreed, which is that Emily, Maximus, Robin and Melissa will remain living in the care of their mother Sonia at home. The only contentious welfare matter that the court has to consider is the role that Mr. Dawes will play within the family, the local authority having considered that it is not at the moment safe for him to be reunited with the family, although they're not opposed to that moving forward, but they would wish Mr. Dawes to engage in some work as recommended by the instructed psychologist before he returns home. It was of considerable interest to me, in fact, that Dr. Shelmerdine does not appear on the witness template. And by that I understand that must mean that Mr. Dawes doesn't take issue broadly with the recommendations that that expert makes. What Mr. Dawes does take issue with, despite the fact that Miss Millichip has conceded that the threshold for the making of public law orders was met in relation to her children, is seek to challenge 13, I think, I will correct my maths, 8, 9, 10 additional witnesses above and beyond the allocated social worker about matters which he has not felt it necessary to elucidate within his response to the threshold document, which, as I've already indicated to Mr. Jeekins, was a wholly unhelpful, and I took it to be, deliberately controlling document in which Mr. Dawes simply used the word denied in response to every response, which wholly defeats the exercise. Having read Mr. Dawes' evidence, however, it seems to be the case that effectively, insofar that there are first-hand witnesses who report that which his older children, Emily and Melissa, have reported at school, he says those professionals are simply lying, and in relation to other issues, he puts a different slant on that which professionals have reported. I do not consider that it is necessary or proportionate or in fact in any way required for Mr. Dawes to have a fair hearing given the issues that the court is resolving. To bring 10 professional witnesses to court, effectively to be told that they are liars. Mr. Dawes will be able to present his case if he chooses to come into the witness box and tell me what his version of events was. That is to say, if he is willing to set out the detail of those events within a statement. But there is no right to cross-examination, as I've been reminded in the documents prepared by Mr. Jeekins and Miss Stiles in response to this hearing. These children desperately need an outcome. The outcome as a result of Mr. Dawes' previous position was that this matter was not going to reach a resolution until almost Christmas, the end of November, which is wholly contrary to the welfare of his children, and I simply am not going to allow that to take place. Good. I am going to list the matter for 3 days, subject to the guardian's availability and the social worker's availability, on the 19th, 20th and 21st of September. And the witnesses that I consider that it's necessary for me to hear from in order to make the determinations that I must are Dr. Hilton, Courtney Nicholson, the allocated social worker and the author of the care plans, the mother and the father and the children's guardian. Mrs. Stiles, is your social worker available?
I have, yes she is, and I've texted those instructing me to find out from Dr. Hilton immediately if they can.
I will accommodate Dr. Hilton's availability at whatever point she's able to assist, and I will allow her to give evidence remotely, Mrs. Stiles. So I will do everything I can to allow Dr. Hilton to give her brief evidence.
I'm sure that the court has seen there are particular arrangements for the father giving evidence. Is the court
I have. I think it's a 20-minute break every hour, isn't it?
It's videoed, and we have to provide questions in advance to be asked by a single person. Supplementaries can be asked in the moment, as it were, but it is to be video linked. There were questions to Dr. Shelmerdine, which I think are, I hope, in the bundle.
Yeah.
No, they're not, which is unhelpful.
There were some questions in an addendum report that I've read. Are there more questions beyond that?
Yes, there are. Yeah, no, there aren't. It's E230. I'm wrong.
Yeah, I've read those. Yeah.
Yeah, we did have some concerns, particularly on my part, about Mr. Dawes seeing the questions in advance, but Dr. Shelmerdine says that is not the right approach. He has to answer the questions when they're asked of him, but I will need in the order today to make arrangements for that to be built into the hearing.
All right. So is it just to help me as to how it's proposed that takes place? It's videoed in advance of the 19th of September or during the 19th of September hearing?
It's pre-recorded.
Yeah.
Which is unhelpful. There may have to be supplementaries within the hearing, particularly in...
Yeah, so I had imagined from that, Mrs. Stiles, when I'd read it, that you effectively were going to set up a separate Teams link at some point prior to the 19th of September to undertake your cross-examination of Mr. Dawes.
That, on my recollection, is the way it's meant to be managed, yes.
Yeah. And then I will have to watch that either during the hearing or beforehand.
And then then the doctor says that supplementaries can be asked within the hearing itself.
Okay. So you're trial counsel, are you?
Yes, I will be, and I can do the dates that are now
All right. So have you had a discussion with your instructing solicitors about setting up that link so that Mr. Dawes can make himself available to give his evidence? Because he'll need his intermediary with him, won't he?
Yes. So it'll have to be done in short order. My instructing solicitor is away at the moment, but I will turn my mind to it after this hearing and make sure that she's fully alerted, and Mr. Walthall and she can make arrangements for it to be put in place.
Yeah. Yeah.
But it was made clear that there may need to be further questions in the light of the answers, and those will have to be asked during the hearing.
Yeah, I kind of, that's the bit I'm struggling with, because if it's the view that of Dr. Shelmerdine that giving evidence in a courtroom will place Mr. Dawes in particular difficulties, then that must be the case for the main evidence, but also for the supplementary questions, mustn't it?
I'm just going back to what Recorder Sanghera wanted by way of questions. I'm reminding myself of those now. I may have to revisit what I've just said. I'm looking at the questions from the judge that he wanted asked of Dr. Shelmerdine now.
Yeah. Are we looking at the case management order of the 17th of July?
Yes.
That's the one that I had read. So the ground rules were a 20-minute break after each hour, frequency of breaks to be increased when Mr. Dawes is giving evidence. When cross-examining the father, keep to a clear chronology, introduce each topic, keep questions short and specific, avoid multiple part questions, avoid front-loaded questions. We should provide Mr. Dawes with a quiet area, which I understand. There'll be a room made available. There aren't any requirements for evidence being pre-recorded, are there?
Your Honour, may I assist on this point?
Yeah.
I noticed Mr. Dawes did have his hand up. I haven't taken specific instruction from Mr. Dawes this morning, but my understanding is, notwithstanding the recommendations of the psychologist and the reservations that the psychologist says about, and the community courts say about Mr. Dawes' perception of his own abilities, Mr. Dawes says that he would feel more comfortable without an intermediary, without an advocate, and unless Mr. Dawes tells me otherwise, I think Mr. Dawes is content with the proposals, or rather the directions, as set out at paragraph 5B257. That's my understanding, Your Honour.
I understand, which will be why paragraph 5 effectively reflects the broad recommendations of Dr. Shelmerdine, but doesn't endorse the full extent of them.
I think that's right, Your Honour. As I say, I didn't have an attendance note from the last hearing, but that's my understanding.
Right, so it would appear, Mrs. Stiles, that Mr. Dawes is going to be in court with us and will give evidence.
In which case I have misunderstood. Last hearing became extremely convoluted. It's the only remark I can think of in my defence, and I'm sorry to have misled the court about the arrangements.
Good.
But that's entirely helpful. So, yes, those are the ground rules, and we'll be doing it, as it were, old style, with careful consideration for Mr. Dawes' need for particular arrangements.
Start. Now, only other witness that I didn't know, who in fact again doesn't, surprisingly, she does appear on the list, was Gabriella Clark, who I think was the author of the parenting assessment. And she was the only other witness that I didn't know whether there might be some question mark about whether it might be necessary for me to hear from her. Has anybody got anything to say about that?
Sorry.
From the local authorities' point of view, she sits entirely with the other. As far as I understand it, the threshold issue is whether or not father was to be allowed to go to Woodbridge. She wasn't, and he wasn't, and that's as far as we say about it. There are remarks made further into the assessments about father's approach. I don't know if father is challenging those.
Right.
But they haven't actually built into our welfare recommendations because we have a further parenting assessment of the mother. Which
I understand. So the only issue that she could possibly help with is whether or not effectively the practical arrangements about the parenting assessment at the time.
Or whether or not father was going to be allowed to go, but say, of his behaviour he wasn't. That should feature in the court's thinking.
Yeah, I understand.
Your Honour, on behalf of father, I haven't taken specific instructions in respect of Miss Clark. I do note that Mr. Forbes has put down 60 minutes for cross-examination. I can only assume that Mr. Dawes had given Mr. Forbes some instructions in respect of that, and I know Mr. Dawes is nodding.
Let me just have a look at how that's pleaded. I mean, I find that difficult, Mr. Jenkins, if I'm honest, as to how Mr. Forbes has reached a 60-minute time estimate. Because if I had a document which said before me, this is what happened at Woodbridge, this is what the people said about me, this is the way that I behaved, and this is why they're wrong, then I would be willing to engage in that discussion. There isn't.
Yes, there is. There is.
Well, let me go back to your statement, Mr. Dawes, and see what you say about the Woodbridge staff and see whether that constitutes 60 minutes for the cross-examination. I'll do the job. have found no factual challenge to the situation at Woodbridge at all. I've just read again the lengthy statement prepared by Mr. Dawes. It doesn't assist me at all, so Gemma Clark falls in the same bracket as with the other witnesses. So my clear determination in the light of Mr. Dawes' response to threshold is we proceed on the basis of Dr. Hilton, Courtney Nicholson, the mother, father and the children's guardian, and Mrs. Stiles. I expect you to prepare a witness template which effectively timetables the matter through to a completion, to judgment. I won't need any reading time. I'll read in advance of the hearing to judgment on the afternoon of the 21st, please. Yes, Mrs. Stiles.
And does that go for the body-worn camera footage that Your Honour will need to see as well?
Yes, I'll watch all of that beforehand.
Your Honour, I note Mr. Dawes has his hand up. I wonder if Your Honour would allow me to take instructions, or whether you wish to hear from Mr. Dawes.
You can speak to Mr. Dawes, Mr. Jenkins.
Your Honour, may I turn my camera off because I'll have to stand up to use my phone?
Yeah, absolutely.
Thank you, Your Honour. I'll be as quick as I can.
No problem. Ms. Van School, just while Mr. Jenkins does that, is there anything that particularly you needed to raise?
No, Your Honour, actually.
All right. And Ms. Sagal, is there anything that you wish to raise?
Your Honour, simply to say the Guardian is available for those proposed dates in September. There was one other issue. She is directed to do an addendum assessment, and I think that was on the basis that the parents would be filing updated statements. Neither parent has filed an updated statement. So could we leave that, if so advised, because it seems unnecessary work if she's not going to be saying anything different.
Yes.
And her report was relatively recent, last month in fact.
I agree.
Thank you, Your Honour.
Yeah. Yeah,
Your Honour, I should have added that the Guardian needs to leave at 11:30 for another court appointment.
And the Guardian's very busy today, I'm aware of that, so I've got no difficulty with her leaving the hearing.
Thank you, Your Honour.
Your Honour, thank you for that opportunity. Mr. Dawes' position is that, as Your Honour has already alluded to, or perhaps suspected, that Woodbridge staff have been changing their position and are lying, and that he has been asking for video evidence, but they've not provided it.
All right. Thank you very much. Okay. Well, Mrs. Stiles, perhaps we just need to revisit arrangements. Obviously, the ground rules for Mr. Dawes to give evidence will remain the same. Whilst Mr. Jenkins was just taking instructions, Ms. Sagal mentioned that there had been provision for the Guardian to file an updating analysis in relation to the amended statements of the parents. In fact, those statements have not been forthcoming, so I'm going to allow the Guardian to file an analysis, if so advised, by the 21st of August.
No updating evidence from the parents that I can discharge that direction.
Well, they had till the 7th of August, and it hasn't been filed, Mrs. Stiles. So I don't think you need to discharge it. The time's gone.
Oh.
So if they were to file any statement, they'd need my permission to be able to do so.
Did I mishear, or did Mr. Jenkins say that Mr. Dawes intended not to use the services of an intermediary at the final hearing?
He intends not to use the services of an intermediary or an advocate. But I will make sure that Gemma ensures that we've got a quiet room available for Mr. Dawes during the course of the hearing.
Template. When does Your Honour want to see a template?
Well, can I have can I have? I'll give you time to file the order, enough time to speak to Dr. Hilton, or those who instruct you to speak to Dr. Hilton, to make sure that she's able to attend. If at all possible, I would prefer to deal with her evidence first on the morning of the 19th. But as I've already indicated, I'll facilitate her remote attendance by Teams any point during the 19th and the 20th. But perhaps you ought to just hold off filing the order with me until we know that she's definitely available.
If she isn't, is the suggestion that she could give evidence at another time, perhaps at 4 o'clock in the afternoon?
Well, her evidence simply goes to her. I know that it's an important issue about the children's feeding and development. That's the issue that she goes to, isn't it? So I could, if she's not available on the 19th, I would be willing to deal with her evidence at another time in advance of then, although I'm on leave until the 11th, so it would have to be effectively at some point in the week before.
Well, let's hope for the best, and I'll be in touch with the court to advise of what any arrangements we might suggest, unless we can hopefully fix it in the trial window.
All right. Anything else, Mrs. Stiles? I did check with everybody else that there was nothing else.
Not as far as I know. I can stand down all the other witnesses. We were meant to be warning them.
Yes.
We haven't embarked on that huge task, thankfully. But I can't see that there's anything else that... there is a paragraph about injunctive relief, as I glancingly referred to it earlier.
Well, that's in response to what the local authority's plan is in order to require Mr. Dawes to remain outside of the family, isn't it?
It is. And I don't make any assertions about him not having done so at this stage. We do have concerns, but I would like to preserve that paragraph that we make an application 7 days in advance and no later, if that's the path that we consider the court should be able to build into its thinking and determination.
Yeah, I mean, you'll have to think about what, if any, order you're asking me to make, and so that Mr. Dawes has proper notice of that application.
Yes, I understand entirely, and we're reflecting that it's far better to move by consent, but the standard, as it were, non-molestation routes don't necessarily avail themselves of the amount of reassurance the local authority might need, which means that we have to fall back on the inherent jurisdiction.
Yeah, Miss Millichip, as I understand it, Miss Van Spal accepts that for the time being Mr. Dawes should remain outside the family home, doesn't she?
No.
Yes, she does.
No, she
yes,
doesn't.
she does, Your Honour.
All right.
No, I didn't agree to that.
All right.
I think that may have informed some of our concerns.
All right. Well, the local authority will have to reflect on that. Okay, it's important that Miss Millichip and Mr. Dawes have advance notice of whatever it is application you're going to make, Mrs. Stiles. So, how long have you given yourself to think about that? Okay.
You're ignoring you, Sonia.
To be reasonable. Mr. Jenkins, is there anything else?
No, thank you, Your Honour.
All right, thank you very much. All right, Mrs. Stiles, I'll give you till perhaps 4 o'clock tomorrow afternoon to file the completed witness template, and Gemma will put the case in the diary for the 19th, 20th and 21st. I'm grateful to the social worker and Miss McCabe for having made themselves available. All right, thank you very much indeed.
Thank you.
Shambles.
Good morning.
call that judge back. Can you believe that again? Even Sonia's solicitor wasn't listening to her instructions. No, because the barristers are supporting social services. And Sonia's been unsure of them of this for a while now. A couple of times she's had to speak out of turn in court because they're going with something she didn't agree with. No, because they've got this whole sexist, paedophilic vibe of me still. And this is how I've been demonised. Even though it's been chucked out of court now, I'm still being demonised as this such a character. I mean, did you see what I had behind me in the picture? One of the claims that at Woodbridge, I wasn't doing the COVID test, which is an absolute lie because I did do the COVID test. There's a picture of one of them. Yeah, and the gas mask that I actually wore during COVID, because maybe I am eccentric a little bit, but I certainly didn't wear a piece of cloth on my face. You know, I wore proper protection at the height of the pandemic before I got further educated. But, I can't believe they've just done that today. Yeah, it's been a nightmare.
Today.
Yeah.
But you will have an opportunity to properly tell the judge your position at the hearing.
I think they did this on purpose. They did this court proceeding out of nowhere, short notice, unprepared, and that's what's happened. And we're only unprepared because you're new to it, which is no way your fault in whatsoever. But it's the way that the court has sort of pulled this trick, this stunt to do it.
What I would say is, the judges, and again, I didn't accept this in court, but what I would say is, that document that your solicitor did for you, that response to threshold, is not up to it. They should have helped you, they should have presented more.
Yeah.
I mean, did they say to you, do you want to more in, or did they just...
Yeah, and I said I've got more evidence, and this is what but every time it's, well, we need this answer, we need that sorted, that's it, that's what we're going with, and we'll further our explanation. But the judge, because we keep getting different judges, it's never set up in that manner. And then she's saying that I'm trying to be controlling of the court. All I'm doing is making sure that if they further slander me, I have the opportunity to rebuttal. That's it. I mean, the COVID thing came out of nowhere at last minute in the last court that I was being accused of it. So I blew up the picture. It cost me £25 to make sure that was present.
Sure, yeah, okay. Chris, I'm sorry things were so flipping difficult, frankly, for you today. If it gives you any comfort, this judge is very, very experienced. She is the top judge, and she might well have a different attitude on the day of the hearing. I'm not going to blow smoke. I'm not going to say she definitely will, but you will have an opportunity to give evidence, and I think you would like to give evidence yourself in front of her, because she'll be able to make a better determination
Yeah.
of what she thinks of you in person, won't she?
Yeah.
Alright.
It's just.
Oh,
it's just. I was kind of hoping it would go the other way, that we were going, this is ridiculous that we're here because of their complaints. They got tedious complaints, and it seems to feel that Mr. Dawes has the evidence to provide against it, and we will. But I kind of wondered why we were doing this out of nowhere, and I believe that it can't be fair that they've done this court proceeding in the way they've done it today.
And that's what I said to the judge, that it wasn't fair that she's getting rid of the people you want to challenge, but she's very clear that she doesn't think they're necessary. And I have to say, in my opinion, again, this isn't what you want there, but in my opinion, the judge is probably right that it's not necessary, because the children are going to stay within the home, they're going to stay with their mum.
And Sonia wants me home, which wasn't clear in court until Sonia had to speak out, but that judge just didn't hear her.
No, and Sonia will be able to give evidence as well, of course. So the judge will hear from Sonia as well.
Yeah.
Okay. Chris, just let me tell you what I'm going to do. I'll give your solicitors what's known as an attendance note, so I'll tell them what happened today. I'll tell them about our conversations, and I'll also consider the order when it comes through, so they'll get a copy of that as well.
Yeah, they're trying to reduce my hours in visitation as well, and I think that's what they're trying to achieve in court today.
They didn't say anything about that today.
No, but they've been trying to push for that recently as some sort of punishment, because there's no reason for them to reduce the hours other than when we've been sick or it's been pouring down with rain and we've not attended, and we've given full notice of that not to attend, but they're using that against us as a reason not to give us 6 hours a week. I'm only getting 6 hours a week.
Yeah, not enough, is it? Chris, is there anything else you're on? Because I need to get on and get this note to the solicitors whilst everything's fresh.
Oh, pass me on to a high court lawyer, that I can start suing them, because I've got the evidence already. I just need a helping hand in the right direction of getting that achieved.
Well, that's something that the listeners will have to deal with. I haven't got a clue for that.
I know, but it's all I ever want right now is just to get into that next room.
Yeah. Okay. All right. Listen, Chris. We won't see each other again because I'm already doing something else.
Yeah. No worries. All the best anyway.